right, so I'm going to get started. So thanks everyone for joining us today. I'm Sharon Campo. I'm a supervising attorney here at Legal Services of Long Island. So today we are hosting our Legal Support Center for Advocates training, Know Your Rights, Contemporary Issues in Education. We have two staff attorneys here with our Education and Disability Rights Project. So we have Danielle Leek, who's a staff attorney, and also Kim Karan. Kim, I hope I'm saying your last name right. So thanks so much. And before we get started, just going to go over a few things. So I know many of you probably already know this, but we changed our name from NASA Suffolk Law Services to Legal Services of Long Island. But we want to make sure everyone knows so that there's no confusion that we are now Legal Services of Long Island. We have our new website, new emails. But even if you go to our old website and accidentally email our new emails, everything should be redirected. So don't worry about that. Still same services, we're still free. So everything's the same, just our name. So today our agenda is first, Danielle is going to do a special education overview and steps toward classification. And then after that, Kim will be reviewing independent educational evaluations, declassifications, and school refusal. And that will also include bullying and DASA. And just a little bit of housekeeping, if you could just keep your microphone muted during the presentation, that way we don't have any background noise. It can get very distracting. If you do have questions, please put them in the chat. You can put the questions in the chat throughout the presentation, but we won't be able to address the questions until at the end of each section. So that way, because your question may have been addressed while we were presenting, but feel free to definitely put them in the chat and then we will address them at the end. I did send out a copy of the presentation earlier today. So if you didn't receive a copy, you can always email me. I'll put my email in the chat, but I do also send it out again after the presentation today. Okay, so just a little bit about who we are, what we do. Legal Services of Long Island has been around since 1966, and we handle about 6,000 legal cases every year. All of our services are free to eligible Long Island residents. We provide direct representation, phone consultations, and brief service or referrals to other agencies. We have offices in Hempstead, Islandia, and Riverhead, and our case handling staff includes attorneys, paralegals, and social workers. And we do have partnerships with community agencies, whether it's Empire Justice, Caracen, A Brighter Tomorrow. So we have many different partnerships. And these are the locations of our 3 different offices. Residents who are looking for our services should go to the office closest to them. Nassau County residents would go to Hempstead, and our Suffolk County residents will go to either Islandia or Riverhead, depending on where they're located. And we have about 20 different programs. So we have different family law programs in Suffolk County, including our domestic violence family court project. We have disability and health related projects, including the Education and Disability Rights Project, who is presenting today, along with our mental health law project and a few others. All of the descriptions of each different unit can be found on our website. So please feel free to take a look at our website and check out the different program descriptions. We have housing units in both counties, whether it's foreclosure defense or our civil unit, which assists with eviction prevention and tenants' rights. And also we have our consumer debt unit in both counties. I do supervise our Suffolk County consumer debt, veterans' rights, our senior citizen project in Nassau. So a lot of different projects covering many different areas of law in the civil arena. We do not handle criminal cases. We do have our Legal Support Center for Advocates, which is for folks who are advocates, such as social workers or case managers who work at other nonprofit agencies or government agencies or other attorneys. Anyone who has a client who is wondering whether or not the specific legal situation their client is in, if that's something that we would assist with, or if we have a referral, or maybe we can just give some quick legal information for that client to help resolve the issue. So our Legal Support Center for Advocates has myself, Kathy Lucidi, Hannah Fitzpatrick. So if you are an advocate and you have any phone questions, please give us a call. Please do not give out our extensions to clients because we can't help them. Clients have to call our direct phone number to be put through to the specific unit. We also do have our community trainings like we're doing today. We publish newsletters. I send out advocate tips every month, so you can sign up for those email advocate tips if you haven't already. Okay, so really quick, we're just going to do some polls just so we have an idea of who's with us here today. Okay, so the first is, what type of advocate are you? So if you could take a moment just to answer that question, I'd really appreciate it. Okay, great. So we're going to end the poll and then share the results. Okay, so we have a few attorneys with us today, a bunch of nonprofit employees, some law students and paralegal students. So thanks so much for joining us today. And let's see, the next question is, have you ever called the Legal Support Center for Advocates? So if you can take a moment to answer that. Okay, just a few more seconds. Okay, great. So let me end the poll. Share the results. Okay, awesome. So we have a bunch of people who have not heard of our program before. So thanks so much for joining us today. And I hope you're able to call us if you're an advocate. And then we have a few people who have used our services in the past. So thanks so much for coming back. Okay. All right, so let's continue on. So definitely check out our website. We have all of our past trainings on there that you can access. We have self-help resources for advocates or clients. And then, of course, as I mentioned before, it talks all about our programs and any other upcoming events that we may have. And then just to know, all of the information that we're providing here today is legal information. It is not advice and counsel. It's not legal advice. Legal advice depends upon the specific facts of a specific situation. And although we do keep our materials as up to date as possible, just keep that in mind. If you are facing or your client is facing a legal situation, please give us a call. And the materials today cannot replace the advice of competent legal counsel. Okay, so with that, I'm going to pass it off to Danielle.
Thank you so much. Hi, everyone. Thank you for joining us this afternoon. My name is Danielle Leek. I'm a staff attorney in our Education and Disability Rights Project. And I'm just going to be starting off the presentation with giving a general overview of the special education process and steps towards classification. Next slide. So first, just a little bit about EDRP and what we do. So we're located in both Nassau County and Suffolk County offices, and we represent students with disabilities between the ages of 5 and 21, and adults with developmental disabilities on a variety of issues, which include special education, residency disputes, matters pertaining to homelessness, OPWDD eligibility questions, and much more. Our supervising attorney is Lynn Iacona. Myself, Danielle, I'm one of the staff attorneys. I'm in the Hempstead office, so I handle most of the Nassau County cases. Kimberly is out in the Islandia office. She's our other staff attorney, so she does most of the Suffolk County cases. And we also have a disability advocate, Marcia Vogel, who helps us out as well. Sorry. Next slide. All right, so first just going over some key terms in special education. So the federal and state special education laws that we work under are the Individuals with Disabilities Education Improvement Act, frequently referred to as the IDEA. Then we have the state laws, New York State Education Law and New York State Commissioner of Education Regulations. And those federal and state laws require school districts to provide students with disabilities with a free appropriate public education, frequently referred to as a FAPE. Next slide. And the way in which a FAPE is delivered is through an individualized education program, which is an IEP. And that's just a written plan to meet the unique education needs of a student with a disability. And the body that's responsible for developing the IEP is the Committee on Special Education, or the CSE, and every school district has a CSE and is responsible for developing that IEP. Next slide. So these are the general steps towards classification. So the first step is the initial referral. So generally parents or teachers or doctors can refer students suspected of having a disability to the CSE. After the initial referral is made, then the CSE will arrange for evaluations of the student's abilities and needs. After those evaluations are completed, the CSE will meet to decide if the student is eligible for special education programs and services. If the answer to that is yes, then the CSE will develop and implement an IEP. And the last step is just kind of a recurring step that happens for as long as the student remains in school. And that is that the CSE must review the IEP at least once a year. And a student has to be reevaluated at least once every 3 years. And that's generally known as the student's triennial evaluations. Next slide. Okay, so now we'll just dive into each of the steps in a little bit more detail. So with regard to the first step of the initial referral, like I said before, parents, teachers, or doctors can refer a child to the CSE, and that initial referral should include the student's name and date of birth, your address and telephone number, a request that the district evaluate the student for special education services, your reasons or concerns for requesting the evaluation, and the request must be in writing. And it's important to make sure that you do include all of the reasons and concerns that you have, just to make sure that the appropriate the corresponding evaluations are conducted. So for example, if there are some speech concerns that you have, or maybe your child or the student has trouble navigating up and down the steps at school, that might warrant a physical therapy evaluation. So it's just important to make sure that all of your concerns are listed in this initial referral. Next slide. So step 2, after that request is sent, the district must evaluate in all areas of suspected disability at no cost to the parent. So the parent shouldn't be paying for these. It's all district funded. If the student is being evaluated for the first time, the district must complete the initial evaluation within 60 calendar days of receiving the parent's written consent for evaluation. So usually what happens is after you send in that initial referral, the district will generate a consent form, which will list the evaluations that they plan to conduct. They'll send that to the parent. The parent has to send that back signed, and that starts the 60-day timeline. If applicable, the assessments and materials used to assess the student must be in the student's native language or other mode of communication. So for example, if the student is from a Spanish-speaking household, then the evaluation might need to be conducted in Spanish. If the parent disagrees with an evaluation that was completed by the district, the parent has the right to one independent educational evaluation, otherwise known as an IEE, at public expense, so again, no cost to the parent, each time the district conducts an evaluation that the parent disagrees with, and IEEs will be discussed later on in the presentation as well. Next slide. All right, so this is just a list of what the individual evaluation must include. So it'll include a physical examination, a psychological evaluation, a social history, an observation in the student's learning environment, so usually the classroom, a functional behavior assessment or FBA if the behavior impedes learning, and any other evaluations needed to determine factors that contribute to suspected disability. So like I said before, maybe a speech evaluation, a physical therapy evaluation, etc. Next slide. All right, so step 3 is determining eligibility. So after the initial evaluation is completed, the CSE will meet to review the results. The district must send the parent a written notice at least 5 days before the CSE meeting is scheduled. And that is true for any time a CSE meeting is called. The parent should be getting at least 5 days notice. And the parents have the right to attend and should attend CSE meetings. If the CSE identifies the student as a student with a disability after reviewing those evaluations, then they'll determine which of the 13 classifications under the IDEA most accurately describes the disability that most directly interferes with the student's learning. Next slide. Okay, so this is just the list of classifications that I just referred to. So there's autism, deafness, deafblindness, emotional disability, intellectual disability. I won't read them all, but again, the point is just that the CSE has to decide which of these classifications is most affecting the student's learning. Next slide. Okay, so moving on to step 4, developing the IEP. So if the CSE determines the student is eligible, they'll go over the student's present levels of performance, or the PLEPs. And that includes 4 basic areas, including academic achievement, social development, physical development, and management needs. The CSE will then develop measurable annual goals, which must include academic and functional goals. And additionally, the goals must be specific and measurable so that progress can be easily quantified. And then the CSE will identify which special education programs and services that must be provided in the least restrictive environment. So that generally includes what's known as a continuum of services. So, whether the student can be successfully educated in a co-teaching classroom, or maybe they need a self-contained classroom, which would be a 15-1, a 12-1, so on and so forth. Next slide. Other things that the CSE must consider: the need for supplementary aids and services. So for example, if the district did an FBA, considering whether a behavior intervention plan is warranted or a one-to-one aid. Parent counseling and training, which is actually required for students with autism. Any testing accommodations if needed. Summer school, so maybe the student needs a 12-month program. The student is eligible for ESY services if needed to prevent substantial regression over the summer months. Any special transportation needs, and adapted physical education if needed. Next slide. Okay, and the last step is the annual review and reevaluation. So for the annual review, each student's IEP must be reviewed at least once a year to determine if the student achieved their annual goals. In the triennial review, the student must be reevaluated at least once every 3 years, unless the district and parent agree in writing that it's not needed. You can also request updated evaluations even if the 3 years hasn't passed by yet, if you feel like it's warranted. But if not, every 3 years, they're supposed to automatically be completed. And then lastly, declassification, which again will be talked about a little bit more later on, but the district must evaluate a student and provide the evaluation report to parents before determining that the student no longer needs services. So the district can't just declassify a student. They have to evaluate first in order to show why a student shouldn't be classified anymore. And if you disagree with that decision, that might be a reason to request an IEE, which again will be discussed in a little bit. Next slide. Okay, so that's the end of my section. If there's any questions, I'm happy to take them now for my part. I'll still be around after Kim does her part as well, if the questions want to wait till later, but if there's no questions now, I'll turn it over to Kim.
I don't see any questions right now. So if anybody does have questions, just put them in the chat. And we can always address them after Kim's portion. Are you ready to go, Kim?
Oh, yes. Okay. I wasn't sure if we were waiting for questions.
Oh, no, no questions
Okay.
right now.
So I'll jump into my section, which is on independent educational evaluations, declassification, and school refusal. So next slide. Okay, so a bit of a closer look at the IEE that Danielle went over in the first section. So independent evaluations can be a valuable tool for the parent when used to determine the student's educational needs. The right to an IEE strengthens the role of the parents in the decision-making process. If the parent disagrees with an evaluation that was completed by the district, the parent has the right to one independent educational evaluation, the IEE, at public expense, which means paid for by the school district. The district may ask why the parent objects to a public evaluation, but may not require an explanation. And when you make this request to the school district, even if you request it in person or on the phone, you should also follow up with a written letter or an email just so that you have the date of when you requested it. So this is kind of important because and we as attorneys also request IE because when you have normally when you have a school district that does an evaluation, they won't put recommendations in. At the end of the evaluation, it will say recommendations are to be made by the CSE or PSE if it's a preschool case. So when you get an independent evaluation, normally the evaluator that you pick will also put recommendations on it. Okay, so next slide. So if the parent requests an IEE at public expense, the district must, without unnecessary delay, either file for due process to show its evaluation is appropriate or ensure that the independent evaluation is provided. If the district approves the independent evaluation, they may provide a list of qualified examiners to the parent, but the parent is not restricted to that list. So if they have someone that they found online or that they know of that they want to use instead, they can use that one. However, the qualifications of the examiner that the parent chooses must be the same as the school district. So you can't request an independent evaluation on, let's say, a physical therapy evaluation and then use a psychologist or psychiatric. It has to be the same evaluation. And the IE is not limited to evaluating the student's academic needs. It may include evaluations for behavioral needs, sensory needs, transitional needs, and other issues that impact the child's education. Next slide. So the CSE must consider outside evaluations brought to the CSE team by a parent. It does not mean the district has to accept the recommendations, but they must review the information and discuss it appropriately. The report from the IEE should be comprehensive, include an explanation of the recommendations. It should not be a summary of findings. It should describe the evaluations conducted, the results of the evaluation, and a list of recommendations based on those results. So just make sure that you review it and make sure it's comprehensive and it was worth asking for the independent evaluation. Next slide. So moving on to declassification. If a school district wants to declassify a student with an IEP, they must follow the correct declassification procedures. Under 8 NYCRR 200.4C3, a school district must evaluate a student with a disability prior to determining that the student is no longer a student with a disability, and the school district must provide a copy of the evaluation and documentation of eligibility to the student's parent. In addition, The parent may state that they disagree with the evaluation and request an IEE. So you still have the ability to get an IEE even during the declassification process. Next slide. So disenrollment, a school district must follow the proper procedure if they want to disenroll a student under Education Law 32021A. No student over the compulsory school age can be dropped from an enrollment unless they have been absent for over 20 consecutive days and the principal or superintendent reasonably notified in write-in both the student and the parent of an informal conference. At the conference, the principal or superintendent determined the reasons for the absences and whether a reasonable change in the educational program would encourage the student re-entry. And the student and parent are informed orally and in write-in of the student's right to re-enroll. Next slide. And so now we can go into school refusal. So what is the legal requirement regarding the school's attendance in New York State? In New York, every child between the ages of 6 and 16 must attend full-time school. So this legal requirement is known as the compulsory school age. Students must remain in school up until the last day of session in the school year in which they turn 16 or until they graduated from high school. The state also allows local school districts to raise the compulsory age in the district from 16 to 17 years of age for those students who are not employed. Next slide. So what is truancy? Truancy occurs when a child of compulsory school age frequently skips school without a valid excuse. Absences are permitted only as allowed by the general rules of the public school. Each school district is required to have an attendance policy describing, among other things, a list of excused and unexcused student absences and tardiness. The policy may also establish a minimum standard of attendance necessary for a pupil to be eligible for course credit. And the school district must provide a plain language summary of the policies to the parents of all pupils at the beginning of each school year. This is generally in the student handbook. Next slide. So what can cause school refusal? In our experience, school districts can misinterpret misperceive school refusal as truancy. In fact, the root cause of school refusal is often related to mental health issues like anxiety and depression. Mental health issues are frequently exacerbated by bullying, both on and off campus, including cyberbullying, most frequently social media platforms. Next slide. So what is the current state of our children's mental health? It's widely reported that the mental health of many American children is at risk and has been so even prior to the pandemic. In October 2021, a joint statement issued by children's health professionals warned of a national state of emergency in the child and adolescent mental health. That organization noted that we are caring for young people with soaring rates of depression, anxiety, trauma, loneliness, and suicidality that will have lasting impacts on them. The statement also mentions that the physical isolation, uncertainty, fear, and grief brought on by the pandemic, together with issues of racial injustice, intensifies the existing crisis. Next slide. In December 2021, U.S. Surgeon General Vivek Murthy warned that the pandemic and other major issues faced by youth were causing devastating mental health effects in that population. During President Biden's February 2023 State of the Union address, he stated, "When millions of young people are struggling with bullying, violence, trauma, we owe them greater access to mental health care at school." In April 2024, Political Magazine reported that state and local governments across the country are scrambling to find new strategies to slow an epidemic of kids' mental health illnesses that are exploded during the pandemic, and noted that levels of anxiety and depression remain sky high. Next slide. So is bullying on the rise? In August 2023, Axios writer April Rubin reported that bullying in schools has shot up over the past 5 years. According to an annual survey by the Boys and Girls Club of America, 130,000 students across the nation between 9 and 18 were surveyed during an 8-week period commenced in February 2023. 40% of participants indicated that they were bullied at school during that school year, which was 14 percentage points higher than in 2019. 18% of participants indicated that they had experienced cyberbullying during that time period. Next slide. So does bullying affect the mental health and educational assessments of targeted students? I think the answer is normally definitely yes. But according to New York State Department of Education guidance issued in 2018, research indicates that bullying and school climate are linked to children's academic achievement, learning, and development. Children who are bullied are more likely to avoid school, more likely to drop out of school, have lower academic achievement, have lower self-esteem, and higher levels of anxiety, depression, and loneliness. Bullied children are more likely to attempt suicide, not only during childhood, but also later in life. Next slide. So how can we assist a school avoidance student struggling with mental health and or bullying issues? In our practice, we have represented many students who exhibit school refusal due to anxiety and depression issues frequently related to bullying. Often these students also have learning disabilities or other conditions which interfere with learning. Typically, the family reaches out to us when the school district has already contacted CPS due to the lack of attendance. And there is a pending investigation of the parents or guardians for educational neglect. We assist families to address the bullying issues with the school district and to either develop a supportive plan to transition the student back into school, or alternatively, for another appropriate program and services. Under certain circumstances, that may include asking the school district to place the student in another school in the district due to health and safety concerns. Next slide. Is there a law that seeks to protect students from harassment, bullying, and discrimination? So the Dignity for All Students Act, or known as DASA, provides that no student shall be subjected to harassment or bullying by employees or students on school property or at a school function. Acts of harassment and bullying include, but are not limited to, acts based on a person's race, color, weight, national origin, ethnic group, religion, religious practice, disability, sexual orientation, gender, or sex, and that is in the education law itself and in the New York regulations. That's it. So what are the obligations of the school district under DASA? So after a written report of harassment, bullying, or discrimination is filed, the school district must conduct a thorough investigation and ensure that it is completed promptly. If an investigation reveals any verified harassment, bullying, and or discrimination, the school district must, among other things, take prompt action to end the prohibited conduct and ensure the safety of students against whom the conduct was directed. Next slide. What can schools do to help get students back to school? There are multiple ways a school can help a student transition back into the school setting. Schools can and should work with mental health providers who know the student and make them a part of the team. Parents can provide the school with letters from these providers that are comprehensive and have detailed information supporting their recommendations. Districts are required to consider the recommendations, but again, do not have to implement them if they feel they are not appropriate to the situation. Next slide. At times, switching to another school in the district, if there is one available, can provide the student with a fresh start. Schools can also transition the student back through a truncated day. The school should look into scheduling only the classes the student likes or feels comfortable attending to start, and then add on more classes over time as the student begins to adjust. Schools should identify a safe space and person to go to if the student is having difficulty. They should also identify pathways for a student to make up the missed work. Next slide. Before I end this, I will say that some parents end up being unhappy with the DASA complaint procedure. It's the school district investigating the school. But what one important function of doing a DASA complaint is that it creates a written document that you say when the bullying or harassment happened, who was involved, and that you told the school district about it. So if you have multiple complaints and nothing was really addressed, you can use that as written evidence that you did try and the school district did not address it. But yeah, if you have any questions, please let me know.
Thank you, Cam and Danielle.
Mhm.
We do have 2 questions so far. So the first question is, what is the relationship with early intervention and the school district?
So I can take that one. So the relationship basically is that students who are eligible for early intervention receive those services up until they're 3 years old. Once they turn 3, they age out of early intervention and are supposed to be referred to the CPSC, which is the Committee on Preschool Special Education. The CPSC ideally should consider what early intervention services the student did receive and any evaluations that were done. And then the process of like discussing whether they're eligible for services and all of that kind of is similar as it was under the CSC, like I just explained during my part. So that's the relationship. Unfortunately, what we're finding recently is that once the student turns 3 and the early intervention services are cut off, there's a delay in getting CPSC services because a lot of the preschools are already filled up and there's not a lot of seats for special education preschools. So that's been an issue that we've been facing recently. I will say that if that happens to be the case with either you or someone you know, you should contact. And so if your child has an IEP and is supposed to be in a school and receiving services, at the very least, the school district or the CPSC should be providing you either with some kind of home services or agency-based services. So once a student ages out of early intervention, ideally services should not just be cut off. They're transitioned to the CPSC, recommendations for services are made, and then ideally they go to school. But we've just been finding that that's sadly not been the case. But the school district should still be providing some kind of services to your preschool age student if they're eligible for such services.
Sorry, I was muted. Thanks, Danielle. Next question is, what is the waiting list like to receive services from your organization?
So for our unit, it kind of depends day by day. You know, sometimes it depends on our caseload. Right now, I think we are accepting cases mostly on a advice and counsel basis. So there is no waiting list right now. You know, you can call and we kind of decide based on our initial conversation with you exactly how much work might need to be put into your case and then decide if we can take it on at that time.
Okay, thank you. So this is also a similar question. Am I still on mute? I'm not, right?
No.
How do you determine whether a student is eligible to receive services from your organization? And then this is 3 parts. Is it based on parent, guardian, or student's immigration status? And do you have attorneys that speak Spanish? So 3 separate questions.
So I guess the first 2 parts of the question are kind of related. So when you call our front desk, they will screen you for eligibility. So we consider the parents' income we consider the parents' income. So assuming that the student lives with the parents, and we go by the federal income poverty guidelines. So less than 200%, you have to fall within less than 200% of the federal poverty income guidelines. Regarding citizenship, it's a similar thing. We consider the student's status. We don't care necessarily about the parents' citizenship status. We only care about the students. So if you are of an eligible status for us to assist, then we will. And also if you are income eligible for us, then we will assist. I forgot the third part, I'm sorry.
Do we have attorneys that speak Spanish?
So our particular unit does not, but our offices have Spanish speaking individuals that we use to help us with those callbacks. So if you speak Spanish or someone you want to refer does speak Spanish or any language, please don't let that be a reason for you to hesitate to call us. We are accommodating to many different languages, including Spanish.
Yeah, we have it all set up to accommodate languages. And then I think there's a follow-up question. It's not coming up in the chat because it's a direct message to me. What is eligible status? And I think what you're asking about is immigration. And honestly, like because we have restrictions based on our funders, so we can't typically represent undocumented persons. But if someone has status, whether a permanent resident or a US citizen, or there's any other type of status, we ask everyone to please make that referral to us so that way we can screen and see if they are eligible, because we have a ton of different exceptions. So we ask people to please don't not refer just because you suspect that they might not be eligible, just refer anyway. So that way we can see if they're eligible, make an exception. And then also we have other referrals we can send them to if for whatever reason, they don't qualify for us. Okay, so the next question, can a parent request reimbursement for a dues and neuropsych testing? I do not believe the school ever notified the parent of their rights in this matter and only hinted at having the child tested. Unfortunately, the child was not diagnosed as ASD until age 14. Who would I contact to begin the process to request reimbursement?
So your first question, yes, you can request reimbursement for the ADOS testing. I mean, as long as the student is classified and maybe the school district just for whatever reason did not test for ADOS or autism and you think they should have, you can request that they reimburse you for the testing. The person or how you start the process for reimbursement, you can either try to resolve it amicably, I guess, and reach out to the CSC chair or CPSC chair if it's a preschool student, or the director of special education, whoever that is in your local school district, or you can file a request for a due process hearing. That would be the way to request reimbursement.
Awesome, thank you. So probably first contact CPSC director, and then if that doesn't work, then do the due process hearing.
Right, exactly.
Awesome. All right, any other questions from anybody else? And if you think of something after the presentation, that's totally fine. You can email me and I will send your question to Danielle and Kim so that way they can follow up with you. The due process hearing, how is that done? That's another question.
So I think every school district has on their website like a form that you can fill out in order to request the due process hearing. If not, you can just go on the state ed website, New York State Ed's website, and they have a form or sample forms that you can look at to submit the request for a due process hearing. So you just fill that out, include what, the facts of your claim, and then that you're requesting reimbursement. You submit that to the school district in person, and then you have to send it all up to Albany as well. The due process complaint form will have all of the instructions of what you have to do on the form itself. And then that kind of starts the process in terms of that. Then you'll have a resolution session and hopefully it'll just be resolved.
So Danielle and Kim, could you send me a link to that form from the New York State Department of Ed, and that way I can send it out to everybody?
Yes, sure.
Okay, thanks.
Sharon,
yes.
Sharon, it's Lynn. I just wanted to make one further comment about undocumented individuals coming to us for services. I wanted to say that because we represent the student, we go based on the student's immigration status. So if we have under birthright citizenship, if a child is born here, we can represent. So I think that's an important thing to know if you're calling the office.
Thank you, Len. And Len is the supervising attorney of the Education Disability Rights Project. So thank you so much, Len, for that clarification.
Welcome.
So I'll send it a link to that form. Does anyone have any other questions? Okay, so like I said, you can definitely follow up with me and I will send off the question to Danielle and Kim. And I appreciate everyone coming today and joining us, and I hope you have a wonderful Tuesday.